In a contract dispute, who has the burden to show that a contract cannot be complied with because it's unreasonable or unfair or impossible? To find out, you have to read Farage versus Associated Insurance Management Corporation, but it's 19 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of Farage versus Associated Insurance Management Corporation. The citation for this case is 2024 New York Slip Opinion 05873, published by the New York Court of Appeals on November 26th of 2024. The issue in this case is who has the burden of proof to establish that a suit limitation time period is unreasonable or impossible to comply with. To understand and appreciate the context of the case, what I think is helpful to know is that with respect to contract law, cases have held, and basically precedent has held in the country and in New York in particular, that parties to a contract are free to make up all kinds of provisions or clauses that they are both bound to comply with, including things like forum selection clauses, which is agreeing upon where the lawsuit would take place, or choice of law, agreeing upon what law will control, and a suit limitation clause that limits the time. And that kind of a clause would say that a lawsuit, if anything is filed, a lawsuit must be filed within a certain amount of time from when the cause of action arose. And that brings to mind that there are certain kinds of cases where that suit limitation time frame might be impossible to comply with. Let's say, for example, that a lawsuit must be brought within a year of the cause of action arising. And a cause of action arises when a building falls down. It's going to take more than a year to build a building back up. So if there's another clause that says you have to completely finish the rehabilitation first before you file a lawsuit, those are inconsistent clauses because you can't both wait a full year. We can't wait more than a year to rebuild the building and then file a lawsuit because then you're outside of the suit limitation time frame. So there's a case called Executive Plaza that says that that's the kind of circumstance you're in where there's inconsistent clauses like a suit limitation time frame clause and a must complete the project or rehabilitation or restoration clause. Then that particular clause can be held unenforceable if it's unreasonable or impossible. That's Executive Plaza. But that case never talked about whose burden it would be to establish the impossibility or the unreasonableness. And that's this case we have here. What are the facts in this case? The facts are that on August 4th of 2014, plaintiff, who had a multi-unit apartment building in Staten Island, had a 4-alarm fire that burned its building, that damaged its building extensively. There was an insurance policy the plaintiff had with a company that was the defendant's company, but that insurance policy, which is a contract, had a couple of different clauses. One said that any lawsuit had to be brought within 2 years. That's that suit limitation time frame clause. And another clause said there had to be full compliance with all terms of the agreement, including that no loss or damage would be paid until the property was actually repaired and replaced. Okay? So that's that Executive Plaza situation. So when the plaintiff's claim was denied after the completion of the project, after 6 years, which is 4 years after the suit limitation clause ended, the project was completely rehabilitated, restored. And so plaintiff filed a claim and defendant denied it, saying untimely. You're outside of the suit limitation clause period. So the plaintiff then said, this is not fair, cited to Executive Plaza, saying this is impossible to comply with. It's unreasonable to require me to comply with that time frame, given what kind of damage was done here. Defendants moved to dismiss their claim, saying that the 2-year suit barred the provision. And when the court had to deal with this particular lawsuit for breach of contract, for failure to pay off the claim, the Supreme Court granted the defendant's motion to dismiss, said it was past 2 years, and that's the 2-year limit. That's by the very terms of the contract. It's thrown out. They said Executive Plaza does not apply because in this case, the plaintiff failed to demonstrate that they attempted to repair the property within 2 years. So the Supreme Court said it's the plaintiff's burden and they failed to satisfy that burden. The plaintiff then appealed to the appellate division and the appellate division affirmed. They said the 2-year limit was established and it was the plaintiff's burden to overcome that by showing that it's unreasonable or impossible, and they failed. Plaintiff then appeals to the Court of Appeals. And here we have a 4-3 majority split decision. The majority here, which is Judges Singas, Canatero, Garcia and Troutman, they uphold the motion to dismiss. They say the judge got it right. They're going to support the judge's decision. Why? They say that it's the defendant's motion to establish that motion to dismiss based upon CPLR 3211A 1 and 7. That it's the defendant's it's the defendant's burden to show that the contract says that it's 2 years and the plaintiff is beyond the 2 years. They met that burden. Now it's the plaintiff's burden. The burden then shifts to the plaintiff to show it was unreasonable. And here the plaintiff failed, just like the Supreme Court and the Appellate Division said. Why did the plaintiff fail? Because the plaintiff only made conclusory claims that the suit limitation period was unreasonable. They failed to allege the specific actions the plaintiff had taken to complete the repairs within 2 years. They didn't provide any details regarding the extent of the damage other than saying it was massive or why the restoration couldn't be done within 2 years. And the plaintiff's failure to plead or respond to the motion with the particulars means they failed to meet their burden. There is a very strongly worded dissent by Judge Rivera, joined by Wilson and Halligan, that says that's not proper, that our rules in New York is we have a liberal pleading standard. It's only the plaintiff's burden to establish that there's a cognizable claim here and that under this particular circumstance, on a motion to dismiss, it should have been denied. But once again, the majority here says it's the plaintiff's burden to show the Executive Plaza unreasonable or impossible, and the plaintiff failed in this case. And that's the case of Farage versus Associated Insurance Management Corporation. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.